Hi, everyone. Welcome to another episode of Talking Deals with David. And today, as you know from all the posts that have been flying around the last few days, which for whatever reason had a Star Wars theme associated with them. I'm not sure how that really connects to indemnification, but I had heard that there's going to be 3 new movies released. And so as sort of a diehard Star Wars fan, I decided, we'll talk indemnification in Star Wars. But I think it's going to be a great discussion today. I know that some people have messaged me saying indemnification is like really boring. It's buried in the back of the agreement. It seems to have a lot of very convoluted provisions, especially in the M&A world. Some of them can be 5, 6, 7, 8, 10 pages long when you add in definitions and everything else. So it is a very challenging part of the negotiation of an M&A deal in particular. But I think it's one that does have a lot of interesting, side areas that you can travel down and important tips and traps to avoid as you're negotiating an indemnification provision. So it's not going to be all me talking about that today. So luckily, I'm joined by Kim Karr, who's the senior counsel at MSA, the safety company. Hi, Kim.
Hi, everyone.
Hi. Great to have you here. And also, because how can you really discuss indemnification, whether it's in an M&A agreement or someplace else, without getting the litigation angle that's associated with that? And so I'm joined by my partner from Nashville, Jason Callen. Jason, nice to have you.
Great to be here.
Yeah, it's terrific. Well, let's jump into it, because I think, one of the things I worried about as I was thinking about how to kind of frame this today is there's so many different areas that you can talk about when you're thinking about indemnification. And then when you add on to it a lot of the developments that have happened over the last decade or so, things like rep and warranty insurance, the very seller favorable markets that we found ourselves in, from really 2012 or so all the way until perhaps the middle part of last year, you had a lot of different forces that were conspiring to really shift the landscape from indemnification when I started, where it was a much more buyer-centered, buyer-favorable type of provision that you would see in agreements. So we'll touch on some of those. But Kim, when you and I were talking about doing something together, and I was trying to entice you to do one of these LinkedIn Lives with me, we were kicking around a bunch of different ideas, but I could sense, at least, if I read it right, were very kind of interested in this idea of indemnification. So maybe kind of talk about why that is. Why do you, like the idea of thinking about indemnification, and how does it relate to the work that you do on the commercial side as well as M&A?
Yeah, happy to. And I have to give my disclaimer, right? I'm a lawyer, and say the views I express today are my own, not necessarily those of my employer. Okay, but getting into it. Indemnity is such an interesting topic to me because there's so many different facets of it. At its core, it's just an agreement to take financial responsibility of another, right? And that could come out of common law, it could come out of your contract, statutory, obligation. And so it's interesting to think about all the different variations of it. But I think that day we talked, David, it was really on my mind because I had just read a case. 2 parties sued each other. So plaintiff sues defendant. Plaintiff gets damages. It's a contract claim. So there was a breach of contract by the defendant. Plaintiff gets damages. But the parties had an indemnification provision in their contract where it ended up that the plaintiff had to pay for the attorney's fees of the defendant, even though the plaintiff didn't do anything wrong. And the attorney's fees ended up being more than the contract claim itself. And so a lot of times we read these things, we think that's an absurd result. How could that happen? But it underscores how important the indemnification provision can be. Plus, you're the expert here, David, so I wanted an excuse to pick your brain too.
Oh, now wait. Now you might be disappointed. Then I thought you both were the experts on this. No, well, you actually, Kim, it's a terrific point. One time a long time ago, actually, you might have been at K&L Gates around that time. I decided to try to go down that rabbit hole of figuring out where did some of these indemnification provisions come from in the M&A world. And I don't recommend anybody try that. You won't get any satisfactory answers from it. But what I did learn was something similar to what you described, Kim. One of the trends that has developed in M&A indemnification are these excluded loss provisions. So you basically have an indemnification, provision that says that let's say the seller will indemnify and hold harmless the buyer from certain things. The typical things might be breaches of reps and warranties, but it could also be standalone indemnification. Maybe there's a certain piece of litigation that the seller is going to retain responsibility for, or it could be taxes for pre-closing periods, or any of the other things that may come up in diligence in a deal, of which there can be dozens, and potentially some of those are subject to this indemnification. But what developed over the last decade or so are these very broad excluded loss carve-outs that sellers will place into agreements. And basically it says, on one hand, I'll agree to indemnify you for these claims, for these risks, but I won't agree to indemnify you for a whole laundry list of excluded losses. And if you look at some of these, it covers almost everything from consequential damages that we'll talk about. What does that really mean? Does anyone really know? To things that you would think of as being normal contract damages, like diminution in value or loss of value, incidental expenses, and the list goes on and on. So I kind of dug into that a bit to figure out, where did this thing come from? And the closest I could come was some cases in construction business where you had contracts that were relatively, fixed sum amounts, but you had damage awards that were, very large in proportion to that. And so in the commercial world, you started to see these developments where you would exclude consequential damages or other types or classes of damages. And I think it got imported into the M&A world. It's a bad parallel. Those are completely different situations, but we as M&A lawyers have to kind of fight that. Do you see, I assume in the commercial side that, how you classify damages and what you include or exclude is pretty common practice when you're doing software deals or technology type commercial arrangements?
Oh, absolutely. And, you're talking about the construction context being where this emanated from. The great irony, of course, is now a lot of states have anti-indemnity statutes. In the construction world, you might be like, yay, I got this great indemnity. Oh, but I can't claim against it for my own negligence or whatever someone might try to do. And so that's always important to know what industry you're working in and the limitations of that. But yeah, to answer your question more broadly, it really does vary by industry. In some industries, there's even a norm of something like in construction, you have AIA documents where to deviate from the kinds of damages that you might get would be very strange. There's this expectation versus other industries, there might be more norms, but not a set type of provision. And if you go to something like a term scout, which is a service that you can see what's like a what's market for commercial context terms, you'll see that often indemnity provisions are excluded from the limitation of liability cap, both in consequentials and in your direct damages. So it is very interesting. It does vary by industry, and often the size of the deal too, and the risk, right? The risk that either party is taking on or posing to a transaction.
Yeah, well, definitely. And you have to. We were talking before we got on the air that you can't sort of cherry pick particular provisions of an agreement and look at them. In a way, that's one of the complaints I've had for these market studies. I think they're of course very useful, and it's very helpful to get some directional guidance and maybe a little bit of a gut check as you're thinking about certain provisions. But the problem is, unless you really understand the overall dynamic, it's very hard to know what to do or what's market when you see something that says, well, in 60% of the deals, we have this provision in 40. My question is, well, what makes the 40 or what makes it in the 60? And a lot of times it has to do with what you were mentioning, the overall negotiating dynamic, the particular industry, the valuation. Generally, I find that the more a business is valued relative to peers, I think buyers typically will expect stronger protections, which makes sense. They're paying a higher multiple or higher value for the asset, so you expect that you're going to get value for that, and so perhaps they have a little bit of a stronger view on indemnification. But you raise kind of a threshold issue, Kim, and Jason, maybe I'd be interested in your thoughts. Indemnification is an odd word. It's something, at least in the M&A context. I think most lawyers who are not M&A lawyers would think of indemnification along the lines that, Kim, you were kind of mentioning in the construction field, that if a third party asserts some claim, then somebody will come in and protect you for that or indemnify you for that. In the M&A context, it's a little weird. There can be third-party claims where it does make sense to use that. But there are also, I think, probably more common just direct claims from the buyer against the seller for things like inaccurate representations and warranties or pre-closing taxes or other things that really don't fit well in the context of indemnification. But Jason, I want to get your sense on just generally that sort of idea, and how do you, at sort of a macro level, what are you thinking about when you're looking at these M&A agreements, and particularly the indemnification side, when you're called in? I assume a lot of times after the fact, although we'll talk about why it's a great idea, I think, to bring you in before a contract is signed. But what do you think about the discussion that Kim and I had and this overall view of indemnification in sort of the M&A context?
No, you're absolutely onto it, David. And just thinking about the term, I wish we could come up with a different term than indemnification, because to my ear, having practiced now, you mentioned this kind of trend started about 10 years ago. I've been practicing longer than that. And certainly indemnification, to me, when I hear that, I think of third-party claims. And when I started practicing, when you heard indemnification, whether it was within a contract or it was within the common law indemnity type claim that I'm sure we'll be talking about, it was always in relation to one party paying another party, contracting party's cost because they had incurred a liability from a third party. That's changed now in the M&A world, and I guess thanks to your research, we'll know that we can blame our construction law partners. Right. For this development. But what it really is, previously when I was representing a party, whether it was in an M&A deal or any other type of breach of contract deal, you would look to the terms of the agreement. You would see which a provision was allegedly breached, and you would determine, okay, do you have a claim or do you not have a claim? And let's proceed accordingly. If there's a forum selection clause, we'll proceed in that form. But now in these M&A deals, what the indemnity provisions are used to do is really set the playing field for any and every type of breach of contract claim, such that you have to immediately look, once you say, okay, there's been a breach of this provision of our sales document, of our merger document, you then have to immediately after you look at that, well, let's take a look at the indemnity provision. Is there any, breach of contract remedy for a breach and violation of that provision? If there is a remedy, what can you do? How much can you recover? What are the hoops that you need to jump through notice wise? It pretty much takes what was just your traditional breach of contract claim and sets up both the procedures and the substance that you have to follow when you assert that the other side hasn't held up their end of the bargain.
Yeah, it's really, that's fascinating, Jason and Kim. I think a helpful way to look at it, and I'm curious, kind of your perspective on also the commercial side, is almost pretend that you don't have any special indemnification provisions in the agreement. You could have an M&A transaction that doesn't have any special provisions, as Jason described them, around indemnification at all. And in some ways, that would be fine because it's still a contract. And so you still have your common law contract remedies. So if you didn't have anything about indemnification in the agreement at all, you as a buyer would still be able to sue for inaccuracies in reps and warranties, or if you had covenants that said the seller will agree to, discharge these liabilities, or or pay for this particular litigation that is a pre-closing matter. And if the seller breaches those covenants or obligations, or there's inaccuracies in the reps, you would have breach of contract remedies. Of course, there are gaps in those. One big one might be the ability to recover attorney's fees, which typically you would not get at common law. But there may be others around what's the scope of the damages, what's the process, what's the timing, when do they survive. So all of these little wrinkles and nuances that come through on an M&A deal, you end up seeing in these fairly lengthy standalone type indemnification provisions, which as Jason said, are really just a way of, in a sophisticated transaction, trying to put guardrails around who has claims, what type of claims, what limitations are there on bringing those types of claims, what damages are recoverable. In the commercial world, though, Kim, my experience, and I'm curious to see if that's changed, is that you might have some of those special indemnification provisions for IP, as an example, but that you generally don't have very lengthy indemnification type provisions in commercial agreements, other than those sort of limitations, things like consequential damage waivers or other limitations that you might have, like a cap or something like that. Is that true? Or are you seeing, more fulsome indemnification, provisions that might be more similar in an M&A deal?
Yeah, David, on the commercial side, that's very true. So what you tend to see on the commercial side is more of the indemnity around third-party claims. And even if you didn't have that indemnity, we talked about things like common law, or even you might have UCC remedies, whether it was direct or if there was a third-party claim involved. But what the indemnity is really giving you is certainty. And certainty is just so important for two parties in a transaction. But that's right. It tends to be limited to third-party claims for indemnity. And then what Jason and you are describing as these remedies for contract claims vis-a-vis the parties themselves, that tends to be spelled out elsewhere. You might have similar guardrails, but it might appear in the reps and warranty section, where you would put something like the sole and exclusive remedy for the breach of warranties. And that's where you would list out, hey, here's the claims that you might be limited to.
That's interesting. Well, that means you need to be a little more, in a way, that means you have to be a little more careful, though, in terms of how you're reading documents, because you may find things that have real substantive, limitations in places that you wouldn't ordinarily expect, especially if you're an M&A lawyer, where maybe you're used to seeing them packaged, in one article or one section of the agreement. It sounds like it might be spread out.
Yes, I think for any M&A lawyer maybe transitioning to the commercial world or thinking about that, one of the changes in expectations or changes in drafting is going to be trying to look for the remedies vis-a-vis the two parties directly to the transaction out of the indemnity context. But in addition to that, another thing to get used to is the scale of commercial contracts. So in the M&A context, you might be focusing intently on just this one contract, getting your indemnity, chipping away at it perfectly right, making it exactly right. In the commercial world, you might be having 50 of those transactions going on in one. And so thinking about scale and operations and how you want to structure your templates and know how you deviate and where, and knowing the business, frankly, like what the business can sustain or should sustain, is also really important too. And that's a big change, I think, going from the M&A world to the commercial world.
Oh yeah, I hadn't thought about that. That is really interesting. It's sort of a different, you're zooming out and in different ways, and obviously there's different things that are going into it. Jason, one thing, this might be a little bit of a rant on my part, but one thing that you hear about a lot, and you'll read about, is that law schools, in their teaching, the case method, all the things that we're used to doing, having gone through law school, is not great in terms of training, especially M&A corporate, business lawyers, because it doesn't really give you sort of the practical, hands-on knowledge, expertise that you need to, really function well in the M&A world. I actually think in this indemnification area, in a way, it's a bit the reverse. I think when you get out of law school, many, probably lawyers generally, but I have a suspicion that it's a bit less with the litigator breed of lawyer, because you stay more, I think, kind of enmeshed or steeped in, case law and court, because you're, drafting briefs or motions. So you have that, you're kind of, that's flowing through you a bit more. I think on the corporate side, once you get out of law school, I think there's a tendency to almost forget about case law, keeping up with developments that are happening, whether it's in Delaware, a pretty typical jurisdiction that, feeds out a lot of cases on a variety of different, M&A specific issues, but just general contract law. And I think in this area, that is particularly troublesome, because there is so much case law and overlay on the provisions that we're drafting every day in the M&A world, that a lot of times you end up just cutting and pasting things in without really understanding what the practical impact, whether you're on the sell side or the buy side. So I think that, talking with someone that is used to every day dealing with disputes and keeping up with the sort of the latest case law is really important. But I wonder what your reaction to that is. Do you think that this is an area where it really does pay to read a little bit about the different types of indemnification, where the courts are coming out on what consequential damages mean and the scope of losses? All of those things that we just sort of take for granted can make a real difference when you're in your position, where you have to actually go in front of a court and try to recover money, or try to fend off a request to get money.
Absolutely. And how it can matter really, David, not surprisingly, is it a lot of it flows again from what law is going to govern the contract. And that goes, the parties usually are sophisticated enough that they're often choosing the law of, perhaps the forum state where the deal's being done, or the buyer seller, or they're choosing Delaware. So once you do that, once you kind of are thinking about the selection of which state's law governs, that matters, particularly on this indemnification issue. So there are some states, take Delaware, for example, that are now developing a pretty well-established body of law when it comes to these indemnification provisions. They're looking at them, they're interpreting them. There's all kinds of quirks that are coming out on things. Like, just to give you one example, there's recent Delaware authority as to whether when you're alleging a breach of a rep and warranty claim, whether it matters that the party who is alleging that breach of the rep and warranty actually knew that the rep and warranty wasn't true heading into the deal. And so a court would say, in the absence of a knowledge requirement or non-requirement in the indemnity provision, Delaware courts say knowledge of the party asserting the breach of the rep and warranty doesn't matter. So you need to be aware of that. Conversely, also, you need to be aware if you've ended up selecting or thinking that a different state than Delaware's law will apply, because there are a lot of states whose legal authority just has not caught up to what's going on with these indemnification provisions. And if you have a really slimmed down, just to take one example, if you have a slimmed down indemnification provision that you think provides you enough protection and coverage to kind of set the proverbial playing field for breach of contract claims, and that otherwise the common law of the forum state will fill in those gaps, it may well not. Because a lot of forum states, when you'll go to their authority on what constitutes an indemnification claim, all it's going to talk about are third-party claims, because those states just haven't caught up. They haven't had disputes that involve these types of sophisticated transactions with really detailed indemnification claims. So you have to be both aware of what's going on in the law, and then be really thoughtful about what state's law you decide should govern your agreement.
Yeah, it's such an important point, and I'm almost thinking now that I've been doing these LinkedIn's for 6 months or so, that's another great topic for something to talk about, because it's one thing that I do spend a lot of time on, and it takes a little bit of strategizing. So one of the complexities is you almost have to play a bit of what do people call it, like three-dimensional chess, because you don't necessarily know which side of a particular dispute you're going to be on, or how a particular dispute may come up. You may have ideas about it. So when you're thinking about a choice of law question, you can almost get into like a complicated decision tree of going down different routes. There might be some advantages to New York law when it comes to, can I get an injunction, or what are the standards? Do I have to, show a probability of success? Do I have to show, greater than that? There's all these different standards that might come in, and things like sandbagging that you were talking about. You may have, slight differences in between Delaware and New York, and maybe dramatically differences when you look at a state like California. So thinking that through, and then also deciding, how am I going to approach that? Oftentimes, if you try for that state law that you love the best initially, you may find some pushback. Alternatively, you might pick sort of another one that you like, with the idea that you'll be able to do some concessions and end up where you expect. So sort of thinking ahead a few moves makes a big difference. But it's really a terrific point about that. And I did mention I was going to talk about, and I think, Kim, you and I talked about this maybe on one of our other calls. People always ask me, why do they say representations and warranties, and what's the difference between those? And there really is a difference. Jason, you probably deal with that more than we do in the corporate world. There can be differences as to whether something is a representation or a warranty, and what the remedies might be. Now, in M&A today, we've sort of crammed those together. So we don't, in an agreement, have a separate list of representations, which usually mean this is what the facts are now at a particular point in time, and warranties, which sort of suggests that the seller is agreeing to stand behind something regardless of what the state of facts might be in the future. But in Europe, you see some differences where they refer to them as warranties. They don't really have these same concepts of representation, but it can impact, can you rescind an agreement? Does there have to be justifiable reliance by a buyer, which goes to that sandbagging? And whether you call something a representation or a warranty, can have some substantive differences in more of a litigation context. But thank goodness, I think for us drafting it, we typically just, as M&A lawyers, just sort of combine them all together. But have you seen those sorts of differences where courts, Jason, are looking at, whether a contract is more like a tort claim? There's a lot of imported concepts in indemnification that sound like tort. It reminds you of that, of the idea of sometimes buyers trying to make a tort out of a breach of contract claim, maybe so they can get out of the caps or other limitations that might be in agreement, or maybe they can try to get punitive damages or rescind the deal. Or do those claims come up in M&A, in the M&A context, from time to time?
They are coming up a lot more, and it's a great question, David, because it's again, this is something that is fast developing. So in my experience, going back a couple decades now, it was not uncommon to have some type of tort claim in connection with a breach of contract claim. But typically that tort claim that was in connection with the breach of contract claim that a plaintiff might bring was one for something like fraudulent inducement. And the idea was to rescind the contract, put the parties back in the place that they would have been if they'd never entered into the agreement. And that was really kind of the sole remedy that was sought. And there's a well-established body of law in most states, including Delaware, that's still out there that kind of tries to limit parties to bringing those types of tort claims. And that state's law, a lot of times the rules that are described are anti-bootstrapping rules. What it's intended to do is to prevent plaintiffs from bringing a tort claim against their contracting partner that is based solely on a breach of the party's agreement. So if you've got a breach of contract claim and that's your sole injury, then your sole remedy should be breach of contract. Now, what's developing are ways that parties are trying to not only get around the bootstrapping rules, but really trying to get around these indemnification provisions. Because what we've talked about is these indemnification provisions, they're setting up those proverbial guardrails on a breach of contract claim. And a lot of times a buyer or seller may want to try to bust through those guardrails. And what's the best way that you can bust through those guardrails may be a tort claim, best and only way. So what you'll see, and I'm sure we'll pivot to this either right now or down the road, are a lot of fraud claims. Fraud claims that, this was a fraudulently made rep and warranty, something along those lines that would try to enable a party to get out of the limitations that are imposed in the indemnification provision. And it leads to all types of issues because for the most part, courts and judges are pretty well trained and have in their minds that if a party says fraud, then whatever is in the contract may well not matter. It just doesn't. Like when I hear the words fraud, and if you come in and prove fraud to me, something within connection of the agreement, I'm not going to bind you to what that agreement is.
Yeah, that's okay. So Kim, now I'm going to loop it back, and then let's talk a little bit about that fraud, because I agree, and I think there's some, economic reasons why you're probably seeing more of these claims. But Kim, you touched on that because you were talking about this exclusive remedy, type concept that when you're negotiating an agreement, especially if you spend a lot of time doing it, like in an M&A world, but it sounds like it's the same in a larger, let's say, dollar amount commercial contract. You want the remedies that you are, drafting and negotiating to kind of be your guardrails or to be the framework. So what did how do you view that exclusive remedy type provision? Is that the way, you think of it when you're looking at commercial agreements?
Yeah, I mean, and again, the best thing you can do in that commercial transaction is provide certainty for the parties. So you want to think through what's likely to happen, what's, market. But I think even more important to that, and this may be pivoting away from your question a little bit, but to me, it's this really important point as a business attorney is, yes, think about the indemnity, think about the remedies, but also think about what could you do to prevent even looking at the indemnity? And by that, I mean, the indemnity and the remedies don't save you or they're of minimal value if the person that you're contracting with, one, can't pay them, it's a credit risk or something like that. Or they're just not a good business partner. So your due diligence on the front end of making sure that whoever you're contracting with is actually going to save you so much time and heartache looking at your remedies and what you can get out of the contract as well. And the more that the lawyers can be proactive on the front end and helping the business vet out partners and looking at that process and thinking through those things, the better off you're going to be in general.
It's a great point. It did pivot a bit, but in a perfect way, because actually, as the market has moved, and I'll give you a 30-second kind of overview on it. When I started practicing, there was no rep and warranty insurance. Basically, sellers were fine with agreeing to fulsome indemnification, not only for reps and warranties, but also for a whole list of standalone, we refer to them as, types of indemnification. And the standalone indemnifications don't require proof of a particular, breach per se. In order to claim, indemnification for a rep and warranty, you have to show it's inaccurate, which requires some, evidentiary type proof. On a standalone, you just say this event happened, seller, you agreed to take responsibility for it, and so you got it. But there wasn't a lot of deductibles, limitations, things before a buyer would be able to make claims were pretty low, pretty buyer favorable. And in most cases, you had caps, limitations on the upper end of what a buyer could claim at the purchase price. or 50% of the purchase price, some pretty large, number. There wasn't a lot of argument around those. And what happened as the economy was booming and you had much more seller favorable market conditions, and the arrival in sort of the late 2000s, 7, 8, 9, 10 period, really taking hold 2012, 13, 14, you had rep and warranty insurance. Well, what happened was, caps started to fall, deductibles started to rise, meaning the buyer would have to accumulate in its basket a bunch more liability losses before it could get anything. And those deductibles started to be real deductibles, so you could only claim in excess. So buyers were taking on more and more risk, more and more liability. And with rep and warranty insurance, there became a natural development that sellers were basically saying, oh, this is great. I can offload this risk to the insurance company. I don't want anything more. And so deals started to look much more like public company transactions, where you typically don't have any ongoing indemnification. Now, we'll see if that changes with rep and warranty insurance now making some inroads into public company deals. That's an interesting, development that I have some thoughts on that are interesting. And you might have some deals where you have some key shareholders at the public company that are very large controlling shareholders, and they might provide some standalone indemnification. But for the most part, in public deals, you don't have any ongoing indemnity obligation. The reps and warranties, as we say in the M&A world, terminate. They don't survive at closing. And the parties just go their separate ways. And Kim, going to your point, in those deals in particular, you have to make sure that your diligence is right, that your valuation is right, that you're picking up on any red flags that may be there, because once you close and once the wires go, for the most part, you're out of luck. But the other development in the private company area of these much more seller favorable agreements, I think, Jason, is what is happening. So you're now constrained under very buyer unfavorable indemnification for the most part. So buyers are becoming more creative at trying to find ways to wriggle out from under those and, circumvent what Kim was discussing, sort of these exclusive remedy provisions. Are you finding buyers successful? I mean, are there good strategies that you can find to allege fraud or allege that something is outside of these exclusive remedy type provisions? And is it enough to just have a merger clause or some other kind of, basic boilerplate at the back in order to preserve those kind of remedies?
So in the complicated answer is it really depends upon what the measure of success is, in terms of whether buyers are able to get around this. So what it does, what I have seen that it enables buyers to do, is to get past a pleading stage where they might otherwise get knocked out from the very beginning just based on the plain language of the contract. If they can plead fraud, they can put forward some facts there, then you get past the pleading stage and then you get into discovery. And now I haven't seen any parties successfully use a fraud claim and prove fraud, go all the way through a bench or jury trial to then, successfully have proven fraud to get around the contract. But for the most part, all they're looking for is to get past the pleading stage, to get into some discovery. And as we know, most of these complicated transactions never make it to trial. They just don't. The costs, the risks are too high for both sides, and you end up having a settlement. So what they do enable to do is to allow the buyers to exert some pressure. If they can plead enough to get around those contractual provisions, they can get into some discovery, impose some risks and costs on the seller, and the seller, for the most part, might just say, okay, let's put a price tag on what we need to do to get this over with.
Yeah, it's really true. It's almost as if you survive those preliminary, motion practice, and you get your complaint to survive a motion to dismiss, or maybe even at a point where it's surviving a summary judgment motion. Then you really you're in a position there where there's a lot of risk, and you do see some of these cases in Delaware go to trial on sort of expedited basis, but most will settle. Kim, there's a great question from Tanya on this on the commercial side. And by the way, if we do have the questions available, so if people are listening and you want to ask something specific of any of us, or we can talk about a topic, just type it in and I'll try to monitor those. But this question, Kim, I think right up your alley. It says Tanya's not seeing as much of the nuanced kind of drafting that you see in the M&A world, maybe multiple different kinds of baskets or deductibles, maybe different kinds of other damage, limitations or thresholds that you see in the M&A world. Caps, I think, are pretty common in the commercial world. But what do you think about that in terms of Tanya's view? Are you seeing differences there, or are there some trends that are developing in terms of caps or deductibles in commercial deals?
Yeah, it's such a great question. And if anyone in the chat has experienced differently or like has a different industry perspective, please type it in, especially on the deductibles, those baskets. Like Tanya said, they're just not that common. I think in some cases, it's because it just feels too complicated. So unlike the M&A world where you're buying this whole company and then both parties might go off and not talk to each other again, you've got this ongoing obligation to your commercial partner and you want it to work, especially if your indemnity is limited to something like personal injury or property loss. And it can just feel so strange to put a deductible on that, especially too, if some of those things are covered by insurance anyway, and you've already agreed to sort of allocate that risk appropriately. So on the deductible side, I haven't seen it. Love in the chat to hear if anyone has a different perspective or thinks these should be going on in commercial transactions. On the cap side, you do see it. I've seen the indemnity itself caps just as part of the normal limitation of liability. I've seen super caps. Those are more common. I think TermScout recently, said in negotiated agreements, the super cap on the indemnity happens at like 30% of the time, which is quite interesting. So if you don't know what that is, it's you have your limitation liability cap, but then on the indemnity, you might say, hey, we're do a super cap 4 times the transaction, or a set amount that's like way bigger than the normal limitation of liability would be. But often it depends on the scope of the indemnity too. So if your indemnity is limited to something that the common law might obligate you to anyway, I think sometimes people feel like, this is just, the standard that you get under common law regardless. There isn't much risk in leaving it uncapped because that's where you're starting regardless.
Oh yeah, that's interesting. So you might have a more tailored cap approach with different kinds of tiers for different things, but you're not seeing, these mini deductibles or mini or baskets or other kinds of limitations that and probably not even like, do you see the materiality scrapes and things like that where, for purposes of indemnification, you read out materiality qualifiers or sometimes knowledge qualifiers that are in the representations themselves, or is that not something that you see in the commercial world?
Sometimes on the IP indemnity, which in commercial transactions tends to be like a completely separate indemnity. So you would separate that out. You could see that. I've seen it in drafts, but often it comes out in favor of, hey, that's just what is material. So defining material. First of all, we don't often define material in commercial contracts, I think, in the way that you do in the M&A world. So that just creates confusion. And so often that material word might be taken out, but replaced with more of a concept. So rather than saying material and then the parties fight over what's material, what's not, you would instead try to insert some description that the parties have agreed upon as that threshold.
Yeah. That's interesting. Well, even in the M&A side, you'll occasionally see someone come up and try to define materiality in a dollar amount. You'll say something is material if, it will lead to, or reasonably expect to lead to, damages in excess of blank. But that's a very, very unusual, provision. I think people just don't have a good, feel for what those numbers really are. And it leads you down sort of a whole side set of discussions and negotiations that people, don't. Although in the accounting world, there are senses of materiality. And so, presumably you could import some of that thinking into the M&A world, but no, we usually leave that open. So even a concept as significant as a material adverse effect, what is that? How is that defined? Typically is not defined, by reference to economics. It's left to Delaware case law or, other states. But Jason, now one thing we've talked about, this exclusive remedy. This is, I think, an example of where we've seen some developments that have sort of coalesced, and it's around this fraud carve out. So many exclusive remedy provisions, as Kim described, you'll see those kind of provisions in an M&A deal to cabin and control claims, to say that, look, we've negotiated these complicated provisions. Your exclusive remedy, and again, this usually applies to the buyer because you don't usually see claims the other way. So most of indemnification is built for the benefit of the buyer, who is the most likely party to take advantage of those. And it'll say, so you, the buyer, can only pursue the specific remedies subject to the limitations, like the cap, like the basket, like the definition of loss, whether it includes or excludes certain types of damages. You can't go outside the four corners. And people naturally would say, well, wait a second. States like Delaware don't even allow you to do that. They always will carve out, fraud, because it's like the old, Latin maxim or common law maxim that fraud vitiates everything. If you have fraud, then, the contract itself can be essentially abandoned or rescinded, and you're not limited to those damages. But the way it used to develop, and it's interesting how over time, over a decade or so, it's changed. You used to just have, except for fraud, these are the exclusive remedies. And it was a lowercase fraud. As a buyer, I love that, and I'll still look for that. But as a litigator from at least the sell side, Jason, talk to us a little bit about what fraud means to you, because I think it might be a broader or more expansive type definition than what maybe an M&A lawyer who hasn't, been reading the case law might think.
Right. And so the first caveat is, when you, again, just to come back to your choice of law, what fraud can mean and how it can get defined in an M&A deal can depend upon what state's court you're in, because the state law can vary slightly, but sometimes in material ways when you're talking about a fraud claim. I think it's important to note that fraud is not an instance when I think about it, and when I think about what a buyer would have to prove in order to get around these indemnification clauses. To prove fraud, you're not just going in and saying, well, the seller was really sloppy. They should have let us know this. They had reason to know this and just didn't know this. That, when you start talking about things like that, that's really fits into a bucket of claims that most courts will refer to as negligent misrepresentation. There's not an intentionality element that a plaintiff in that instance is required to prove. And negligent misrepresentation, for the most part, is treated very distinctly from fraud, even though there's some similarities, and the remedies that you can get through negligent misrepresentation are different. Most part, I've not heard of courts that will enable you to rescind a contract or otherwise get around contractual provisions based solely on negligent misrepresentation. Instead, you have to go to fraud. And the big thing there with fraud is that intentionality requirement. You're going to have to prove that the seller knew that what it was stating to you was absolutely false. Nonetheless, you as the buyer nonetheless it made those false representations, and you as the buyer then relied on those false statements in going forward with the deal. So you have to prove not only that the statements are false, not only as the seller that you relied upon them, but you also have to prove this intentionality requirement. And that's really hard. That's just not an easy task for sellers to do. They can usually stay enough to create enough smoke, like we've talked about, to get past the pleading stage, even get to summary judgment, because there's going to be an issue of fact that a judge and jury will have to decide. But I'll say in my own personal case, where we brought both a material adverse change claim plus a fraud claim, we could not, and ended up in a bench trial, we could not convince our judge that a fraud had been committed by the buyer. It was just too high of a hill to climb. Even though we had a fair amount of smoke, it really, what it led to was our judge concluding, they should have done a better job here. They probably should have known it, but they didn't go out to just simply who do you, the buyer.
Yeah, it's a great point. I think what's happened in the M&A practice, just to kind of nail that down even more, is you've seen much more complicated definitions of fraud. So instead of just saying, and these are again seller favorable, developments that occurred, in the past, let's say, 5 years or a bit longer. So sellers are now saying, well, I don't want to have the risk that lowercase fraud might pick up things like negligent misrepresentation, or maybe it'll pick up recklessness. There's categories of fraud that require only a sort of a reckless standard as opposed to maybe a knowing or more intent-based, or fraudulent concealment. Maybe they've hid things from us when we were doing our diligence that if we had seen, we might have approached things differently. They're not making a rep per se, but it's maybe they covered up something in the factory or they did something else. So they took some actions that made our diligence process a bit weaker, going to Kim's point of really, trying to dig in on the front end instead of waiting until claims come up. So these definitions of what the fraud carve out is meant to do have become much more narrow. So now you'll see these pretty lengthy definitions that define fraud as intentional misrepresentation with respect to only the reps and warranties in the agreement, and that those were relied on by the buyer. So they import a lot of those concepts. The idea being that everything else, if fraudulent conveyance or fraudulent concealment or negligent misrepresentation, all those are within the exclusive remedy provision. So that's a seller favorable development that that has sort of happened as the market developed. I think in response to some of those issues, Jason, that you mentioned. But Kim, I'm really interested in the way that you approach sort of these deals and thinking about them holistically. And we touched on that before we got on a bit, but that, these, you can't view provisions in isolation. You have to really think about them in the connection with the choice of law issues that Jason mentioned, boilerplate provisions that may take away some of the things that you negotiated on in the front, the more substantive provisions. So how do you keep in your mind, clear on all of that? Like, what's your kind of approach as you're thinking about a new, commercial transaction or deal in terms of getting started and sort of keeping all of these things in your mind? Because a lot of them have different, it's hard to juggle all these different things, but it's important if you want to actually, provide real value to whether it's in-house as you are, or if you're someone like Jason and I and you're advising clients. So how do you think about that at a sort of a higher level?
Yeah, it's a great question, because there's the macro of the individual contract, or the micro individual contract, and then macro, how are you scaling this for your whole team? So on the macro, there's the bullwhip effect, right? Like, you change one thing in your indemnity, now you got to go back. How does it change warranty? How does it change limitation of liability? How is it changing third-party beneficiaries? How is it changing my integration clause? All of those things can ripple throughout the contract. As well as, you don't want to have a team of lawyers in-house who are doing things inconsistently. Sometimes that can start out because it's just a lack of, experience in a particular industry, or it can be risk appetite for your team. The best solution that I have, if you haven't already done it and you're in-house, is get everybody on a playbook. That playbook is going to tell you, okay, here's what we accept, here's their starting point for something like an indemnity. And then here's our alternatives that we might accept. And that playbook should be explaining that checklist of all those other provisions you need to walk through to make sure that everything is right. Like, insurance could be affected by changes. So if you're going to make a change, hey, here's a checklist of all the other things that you need to go through. Mm-hmm. It also helps educate the team. So if you have a new member on your team, here's what we do, why we do it. And then the other part of a playbook that I can't stress enough is it removes emotional decision making. So whenever you're on that phone call, you've got that pressure. We've got to decide today what that indemnity is gonna say. People tend to have two different reactions. There's the people who just give in because they're very agreeable, and then there's the people who actually dig in more on the other side, and then you're holding up, capturing revenue for your company, for example, or getting some other really important deal done. When you remove the emotional decision making, you standardize it, operationalize it. That's the value that you're bringing to the business.
Oh, that's great. So, and it's true on the M&A side that, especially on the corp development side, having playbooks, approaches of, what kind of targets you're looking at, how do we evaluate them, makes a ton of sense. I think there's a lot less of that on the legal side, and maybe for good reason, because you're not doing as many contracts, and obviously it's much more customized, tailored than maybe on the commercial side, depending on what you're doing. But I really love that approach. So how do you and then do you kind of have an annual process, or who's responsible for kind of keeping that? Because I guess one of the downsides to a playbook is if it's wrong. So if it's wrong, then that's not good, because now you've embedded something in it. But also if it sort of dampens the creative approach, where maybe there's a solution that's right there, but it's not in the playbook. If people don't sort of feel that flexibility to be able to kind of adjust as they go. But how do you kind of address those situations, make sure that your playbook is kind of active, that's a living sort of a thing, and that people, know that when they're using it, it's got good information, good approaches, but that it's flexible enough to, accommodate places where you may need to adjust?
Yeah, it's a great question. So first of all, that playbook should be in a shared repository, and people should be updating it as you do your transactions. So say that we come across a very unique issue, we talk about it as a team, or someone, comes to me later and they're like, hey, I was on a call with the counterparty and they said this and it really sparked this. The first thing we do is we go and we update the playbook. And then we do quarterly revisions of a lot of these things, as well as annual updates. And the other thing about the playbook too is it's not just a legal resource. You want to be sharing it out to your sales and sourcing team so that they can give input on, hey, this is what we see a lot too, or this is how they can help us think creatively about what's in your playbook. And it's not meant to be like an absolute no, you can't ever deviate from the playbook. At least that's not how we do it. In a larger organization, if you've got a lot more people, you might develop a process around escalation. So we actually have, I've seen it where people have built like a process. It might be in like an app, or it could even just be a process that you define where you say, hey, we need to go outside the playbook. We think it makes sense. It escalates to, you might have a contracts committee, you might have just one decision maker in the business and in legal that it escalates to, and people say, yeah, that works. And then if they say, yeah, that works, and it works forever, we love this idea, it's very creative, it addresses an issue, you put it in your playbook, just part of your ongoing practice. And I think one of the things in commercial that, I don't know how you feel about this in the M&A context, but we often say, don't let perfect be the enemy of the good too. So we know that there's a continuous improvement aspect to that.
Yeah, it's a great point. I think obviously on the M&A side, where there's, it's more meaningful, I guess, in some ways in terms of dollar amounts, or significant to the company, the margin for error, I think is perhaps a bit less. So, I guess we'll strive a bit, more toward that perfect, because you just don't know, what the consequences might be if you falter, but Jason, I think it was great, having you. If you could give some advice, I guess one of my pieces of advice was bring in the litigation people like Jason, who really have expertise on how these things go sideways early. I always love to work together on contracts as we're negotiating them, to kind of make sure that, we're thinking about things from the litigation angle, even though you hope and expect that you won't end up in that sort of a posture. But any final words, Jason, on your side in terms of how we as corporate lawyers can work better with, people on the litigation front and, draft hopefully better contracts that work, as people anticipate?
Definitely, David. I love being brought in and being able to help out on the front end. The number one piece of advice that I give to transactional lawyers or to clients who are entering deals is if you don't have it in the agreement, if it's not spelled out expressly in writing, then just recognize at that point that you're leaving it to a judge to decide. A judge who doesn't know your business, doesn't necessarily know the parties, and who is cabined by whatever the common law rules of that forum state. So if you don't define what fraud is, if you don't define what consequential damages are, you're just leaving it to the judge. And that might be okay. You might be comfortable with it. That might be something that you're totally fine with. But if you're not, then be intentional. Get a litigator involved who can help you craft what will be the most favorable language to your party's interest.
Yeah, it's perfect. And Kim, I guess on your side, how do you
Oops, might have just lost David for a second.
I thought it was on me. My end. Yeah, interesting, Jason. I feel like it's so funny to see the commercial view versus the litigator view approach and it's, really interesting.
It absolutely is. I mean, when you're thinking about it on the front end, everybody is so excited to just get the deal done.
Yeah.
Both the buyer and seller, and the last thing you want to think about is how it can potentially go wrong. So, well, great. I think we've reached 12 o'clock, and David's computer might be having some issues, but that's okay. We made it all the way through. Kim, I really appreciate the time and enjoyed getting to spend this last hour with you talking about indemnity clauses and M&A deals.
Same. Thanks, Jason. Thanks, everyone.
Bye.
Bye.